Hello, and welcome to part 1 of the trial preparation workshop hosted by Neighborhood Legal Services of LA County. Today, we are going to cover some of the basics, including overview of the eviction process, what is an eviction trial about, how to get ready for your trial date, how to proceed with your case, and what to expect on the day of trial. This is just the first part of a 3-part series so that you can participate or review each segment that you think is most relevant to you. An eviction proceeding is an expedited process, which means that the courts move much faster than in any other type of case. Specifically, the timeline for an eviction starts when you are served with a notice. That can be a 3-day notice, a 30-day notice, 60, 90, or sometimes 120 days. After the notice period expires, the plaintiff, which may be a property owner, management company, or landlord, can then file and serve a summons and complaint. After they've filed and served the summons and complaint and serve it on you, you only have 5 days to file your answer with the court. Those 5 days do not include holidays or weekends. So you may have an extra day, for example, or 2 if you get served on a Friday. Again, you only have 5 days to answer. If you do not file an answer within the 5-day time frame, you could automatically lose your case. Once you file an answer, your trial date may be set within a few weeks of that answer being filed. And if you get a notice that the plaintiff, which is the landlord, the management company, or the property owner, has requested a trial date, you would only have 10 days to demand a jury trial. On your date of trial, expect the court to want to proceed or for you to enter into a settlement agreement. And we'll discuss the difference between proceeding to trial and proceeding to a settlement agreement in parts 2 and 3 of this series. So what is an eviction trial? It is a legal proceeding to decide whether a tenant can continue living in the rental unit. It is not an opportunity for a tenant to sue their landlord. Small claims is a better avenue for this. So the court is not going to decide whether a tenant is owed money based on the conduct of the landlord. The court is only going to decide who gets the unit and how much a tenant may owe the landlord if rent has not been paid. So how can a tenant prepare for a trial? If you're a tenant and you've been served with an eviction, one of the most important things you can do is gather any recent documents that are relevant to your case. Those may include rental payment receipts, which may also be in the form of bank statements if you have direct deposit to your landlord. It may include money order receipts or pay stubs or receipts that you may receive from the manager. You may also want to collect and review written communications with the landlord or manager, and that may include text messages or email. The court does not restrict the kind of communications that can be brought and presented as evidence. You may also want to include other receipts. For example, if you paid for repairs yourself or extermination services. And if you have any other contracts, writings, or agreements that are different from the documents that the landlord included in their complaint, you would also want to have those ready for you. If there was a government agency involved in inspecting your unit, investigating issues with your landlord, then you want to get certified copies of any inspection reports or letters from a governmental agency. These may include the health department or the housing department of the city of Los Angeles. It may also include any contracts or documents with a third party, such as the housing authority, if you have a Section 8 tenancy. When and how will you get your trial date? Usually, a trial date notice will be mailed to you by the court, and it can be as little as 2 weeks after filing an answer, although we've also seen cases not set for trial for months, and that may entirely depend on your landlord or the attorney for your landlord. And there's a few ways that you can be sure to get updates, especially if your mail is unreliable. First, you can call your courthouse directly and regularly. Once you file an answer, it may be wise to call at least once a week, perhaps every Monday. The other way for you to check on your trial date is through the court's website online. And I'm going to show you ways you can find that information. So how can you find your courthouse's phone number? If you go to the court's website at lacourt.org, there is a tab for courthouses. Each courthouse has its own contact information. So if you click on the courthouse where your case has been set, you'll be able to find address and phone numbers for the department. You would specifically be looking for unlawful detainer department, or the civil department that handles unlawful detainers. That way you can connect directly to the clerk that handles the case that you have. And another way to find out if you have a trial date is to go on the court's website, and if you can connect to LA Court Connect. LA Court Connect is the system where you can register to appear for a hearing date or trial date by phone or by teleconference. Our office does not recommend that you initially appear for your court case by phone or teleconference, and we fully recommend that you go in person to your court date. However, by checking on this website to try to register for a court date by teleconference or telephone, you will see if there's an upcoming court date. And once you get on this page, which is my.lacourt.org/LACC welcome, you'll click on the unlawful detainer tab. You'll answer the questions about how far in advance is your court date. You'll create a login. You click on the schedule and enter your case number, and it will tell you if there are or are not any court hearings. And if there are, it will also show you the time and the department where your trial date has been set, or any hearing has been set if there are any pre-trial hearings, which sometimes are scheduled by the landlord's attorney. Please note that if you miss your trial date, you will lose your case. And that includes showing up late or failing to appear at the time that they call your case. Typically, trials are set for 8:30 a.m. in every courthouse across the county that handles unlawful detainer or eviction cases. So make sure you show up to court with enough time to park and get through security. You check in with the bailiff and be prepared to negotiate or proceed with trial.
Hi, can you tell me where courtroom 12 is?
Sure, it's just up the stairs on your right.
Okay, thank you.
Posted outside of each courtroom door, there will be a sheet of paper listing what cases will be heard that day. This is called a docket. Check and make sure that your name is on it.
When you check into the court, you'll have to find the courtroom where your case was assigned, and also let the bailiff know that you're there so that the court knows that you've appeared for your case. Here's a quick clip so you understand where you'll go and who you should be talking to.
Checking in?
Yeah.
What number?
Number 3?
Okay, plaintiff or defendant?
Defendant.
Okay, checking in for defendant, and got you. Thank you.
Thank you.
The next big decision you'll have is deciding whether to settle your case or to go to trial. Deciding is a really personal decision, and you may want to talk to your family or other household members about what you want and what options are best for you or for everyone in the household. Here are a few details that you may want to consider as you figure out what you want to do next. Well, what do you want? Do you want to stay? Well, let's consider the following. Can you afford to pay rent? Is your apartment rent controlled? Is it subsidized? How much are smaller sized units? Is there any other availability in your neighborhood? If the eviction is based on problems with your landlord, can they be fixed? Do you think you could work through them and continue to live there comfortably? If you have children, will you be able to find another unit in the same school district to allow them to complete the school year? Is staying the best option for all of your family members? Sometimes if there's been a high conflict situation with your landlord, staying is not ideal and may cause more stress for you or other people in the household. If you still wanted to stay after considering all the other options, you may have to go to trial if your landlord does not agree in allowing you to stay. You can still try to settle, and settlement is always an option up until your trial date. And settlement sometimes includes the ability to stay in your unit. If you want to move, some tenants know right away that they're ready to move. And you may want to consider, do you already have a place to go? Are there family or friends that you can stay with in the interim while you figure it out? Is the place that you're moving to guaranteed? Is there enough space there? Do your other family and friends, are they welcoming you and knowing that you may not have a timeline for being able to move out? Can you afford to move? Have you looked at other rental units of the same size in your area or in areas where you want to move? How much are the rents? Do you have a security deposit? If you have a housing subsidy, like Section 8, you may need more time to move because there may be a required inspection or certification documents that must be reviewed and approved. Are you giving up an affordable unit? Have you lived in a rent-controlled unit for a long time and you're not going to be able to find a unit at that price point? And how long will it take you to move? Is your landlord willing to wait that long to get the unit back? If yes, the answer to a lot of those questions are yes, and you still want to move, great. You should definitely work on settling the case with a move-out agreement. Going to trial will not help you, as trial will only establish that you can stay and pay rent in the unit you're at right now. How to prepare after you know what you want. If you want to stay in the unit, it may be helpful if you demand a jury trial. A jury trial is a more involved court proceeding where a jury of your peers, 12 people, will decide the final ruling in your case. Alternatively, you can go for a bench trial and let the judge decide. Either way, you'll have to prepare all your evidence, so have documents, copies, and certified copies ready to go. You'll have to identify and bring your witnesses on your trial date. That may include neighbors, inspectors, or other people who saw some of the things that you're disputing. Do you have money to offer the landlord for fees or attorney's fees? Sometimes your lease agreement may include a term where it says if there's a legal proceeding, a tenant may be responsible for fees. Sometimes it says that whoever wins a case will be entitled to legal fees, and that may be beneficial to you. So it's always helpful to look at your lease. If you owe the rent, having the money for the landlord may also be a step towards settling if the landlord knows they'll be paid for any rent that's owed. Have you resolved any of the issues that caused the eviction or initiated the eviction? For example, was there a pet that hadn't been approved? Or was there an unauthorized occupant who unexpectedly came and started staying with you? And if that's been resolved, do you think the landlord would continue to allow you to stay? If you know you want to settle to move out, Figure out an ideal move-out date, but understand that typically landlords will agree to a short amount of time to stay, between 30 and sometimes up to 90 days, but it's never more than a few months. And often, if you want to stay some additional time, expect that the landlord will want payment to extend the move-out date if they're willing to do that at all. Can you pay any rent or other expenses to the landlord? So for example, if there are other fees that have accrued, if there's unpaid utilities that are causing issues, a landlord may not be as willing to settle for the move-out unless all these other issues are also resolved. In some cases, a landlord will just accept your security deposit, depending on how much is on record, to resolve and settle out some of these issues. You may also want to find out if your landlord will give you a neutral reference. So essentially a reference that confirms that you live there and the amount of time that you had been living there. These are all some of the things you want to prepare and consider as you approach your trial date. Next up, we have part 2 in this series that goes further in detail on settlement agreements, and we have part 3 on the details of proceeding with a trial date. Please be sure to review those videos as many times as you need, and join us for any live recordings that we may have for specific advice on either option.